Hi there, John Crotts at King Law, attorney and elder law specialist. Wanted to share a little bit with you today about handwritten wills, or in North Carolina, we call those holographic wills. People ask me all the time, are these legit? Can I just do my own will, or can I write my own will? And while it's generally not advisable to create your own will for lots of reasons, the reality is the law says that you can actually handwrite your own will. Now, this is not to be confused with typing your own will. If you type your own will, then the form that you use has to comply with North Carolina law and the requirements for a typewritten will, and the witnessing that goes along with that is also strictly covered by North Carolina law. But today we're talking about handwritten wills, which can actually be a good tool, especially in medical emergencies and things of that nature. So, what's required to do a handwritten will? First, it's got to be entirely in your own handwriting. Cannot have someone else's handwriting. It's got to be your handwriting, and all the material provisions of the will. I leave my truck to my son. I'll leave my house to my daughter. Those kinds of things. The clear instructions, the material instructions have to be in writing and in your handwriting. Um, any typed text or handwriting by someone else uh, could possibly invalidate the will. It's got to be signed by you. It's got to have your signature, and it has to. The only exception to that is if you're unable to make your signature due to physical disability, someone else can sign your name for you at your instruction. Uh, but it has to be in your presence when they make their signature. A lot of reasons why that might be a bad idea, but sometimes in very rare circumstances it could be necessary. The signature can be anywhere on the document as long as it shows an intent to sign. Typically, that's going to be at the very end of the document. And of course, the document's got to be found after your death. It does no one any good if it's lost. I tell people when we're talking about where should I store my will, um, there's a lot of good answers to that. There's a lot of bad answers to that. For example, in a book on your bookshelf, hidden, in the middle of a book on the bookshelf is probably not the best place to put your will, unless your whole family knows that's where you're storing it. But typically, a safe or a safe deposit box or a courthouse that will allow you to deposit it there for safekeeping would be good, better choices. So if you can do this, why wouldn't everybody just handwrite their own will? Well, there's a lot of pitfalls to writing holographic wills. First of all, is ambiguity. Lawyers experience a lot of training and learn a lot of different techniques. And I always tell people ambiguity is your biggest enemy, and of course that just means unclear. Being unclear about something or lack of clarity. What may be clear to you in your own mind may not be clear to me when I read it. So you're just opening the door for a legal challenge by other family or other interested parties who could challenge your will because it just wasn't really that clear. So interpretation issues can abound with holographic wills. That's why they're generally not recommended. Um, Failure to meet the statutory requirements, the requirements set forth by the law that we just discussed. If you fail to do any of those things, because it can be confusing, maybe you forget to, maybe somebody else wrote it for you and you signed it. Well, that's no good, right? Aside from the exceptions that we discussed. Uh, Challenges to authenticity. When there's no witnesses to the will, it can be easier to challenge that. Um, and After the fact, there's some additional hurdles that you have to go through to get witnesses to actually sign affidavits to validate your signature. So they're much more difficult to probate. Um, and the will can omit essential provisions that you may forget about a piece of property, or you may forget to include what we call the residuary clause, where you kind of catch anything that's left over other than the specific gifts that you're leaving in the will or the specific bequests. You may forget the leftovers or whatever's left, and failure to do that creates a lack of clarity and can result in the property going to people that you wouldn't want to inherit from you. And these can be easily lost and destroyed, as mentioned earlier. Uh, but if you insist on making a holographic will or know somebody who does, make sure that they write clearly and legibly, and that they clearly express an intention to make a will by the document that they're signing. Uh, Try to include a full list of assets and beneficiaries, at least the major assets. Make sure that you include that residuary provision that we just talked about. Um, Again, an example of what a will might look like is I'll leave all of my personal belongings to my sister. I'll leave my truck to my grandson, and everything else I'll leave to my favorite charity. As long as I've got everything else or all the rest, residue and remainder of my estate, as long as that's included, then you've covered everything. You don't want to leave any gaps. Make sure that you identify an executor who's going to be able to administer your will when you're gone. Otherwise, the court's going to have to appoint somebody, and it may be somebody that you don't want to serve as your executor. Make sure you store the will securely in a safe place. And I'm a huge fan of transparency with your family. Let them know where you're putting it. Um, in most cases, there's some occasions where you may not want to do that, but generally, you want to let the family know, hey, after I'm gone, here's where you're going to find the will, so that it's not a treasure hunt, or they're not just searching all over the place looking for the thing. Um, and honestly, it's a good stopgap. It's a good temporary measure to create these things, but eventually you need to talk to an attorney and sit down and actually have a formal, typewritten, attested will that closes all these loopholes or fills in all these gaps to ensure that your wishes are carried out when you're gone. Um, the old saying, "Penny wise and pound foolish," applies here. It's not that expensive to create a simple will. So see an attorney and get that drafted. If we can be of service in that, feel free to contact us at King Law. Visit our website for more information. We'd be happy to sit down and have a consultation with you. All right. Thank you.